Welcome to my editorial. I am Parveen Kumar, editor in chief of the OpenView. Before I start my editorial, I would like to introduce my this the website, the OpenView. This is a news website. You can visit this website. You just have to type the openview.in. Once you visit my this website, you will find the content which is of very high quality and you will love it. So I request you to everybody that please visit my this news website, the openview.in, and choice your content. Now today's topic which I have selected for presentation is regarding the underlining underlying difference underlying difference between the state and the union territory. As you know, these are constitutional concepts, so it is very important and is of public importance that one must understand the underlying difference between the state and the union territory, which means that if you are a state, then what are its advantage? What advantage the rights you enjoy, your state enjoy? And similarly, when the same state is converted into a union territory, then what rights under such you enjoy? As I have said, that both these two are constitutional concepts. The provisions regarding state and the union territory are laid down under the Constitution of India. So you can visit the Constitution and see yourself the difference between the two. So far as, let's take it one by one. So far as the state is concerned, it is a wider concept, as state possesses its own legislature. It has their own its own council of ministers with one chief minister, which are popularly elected by the people, which means that the people of the state directly, indirectly elect their representatives. It has bicameral system, meaning thereby it has state assembly and it has the Legislative Council. So far as the legislature is concerned, Legislative Assembly is concerned, people elect their representatives who in turn represent the interests of their uh, voters in the state assembly. The system is different in council. So, one important aspect which you need to keep in your mind is that state is a wider concept. It has wider constitutional rights. Like I have said, it has its own council of ministers. It has a bicameral system whereby you get one state assembly and one legislative council where people elect their representatives and send them to the state legislative assembly where they represent their rights, their interests of the people who elect them. This this is not available otherwise if it is not a state. So far as union territory is concerned, union territory is a small administrative unit. I will tell you more about the states. Before that, you understand the union territory also. Union territory is a small administrative unit which is directly under the control of central government, which means what I have explained about the state, the benefits, the systems of the state, which I have explained, those systems are not available under the union territory. Here, the controls are directly in the hands of the center. Whatever center wish, desires, is solicitous, center can do. For example, we have recently seen that a full-fledged state of Jammu and Kashmir has been converted, reduced to a status of a mere union territory. And the people of that state might have also experienced the status which they used to enjoy when they were under the state, and the status which they are enjoying now under the union territory. Here, this is example. Here in Jammu and Kashmir, you will find that when Jammu and Kashmir was a state, then you are having your own elected government with one chief minister and council of ministers who used to look after your interests. and for them there was a bureaucracy to aid the ministers, the council of ministers, the chief minister. So bureaucracy was directly under the control of the chief minister, the council of ministers. They were not directly linked with the people. Now, now it is a union territory. The state of now Jammu and Kashmir is a union territory. Now you can see what you enjoyed when you were a state, you are not enjoying that. Now we don't have any legislature. We have no elected people. You understand? We have no elected people. Now that control is directly in the hands of the bureaucratic system, the bureaucracy. Bureaucrats are your ministers, bureaucrats are your bureaucrats, public servants. We have uh, one administrator, which is called Lieutenant Governor, who is directly appointed by the President of India under the constitutional provisions. So you can well understand the difference between the state and a union territory. Now, what other I will advert your attention towards some of the important constitutional provisions which deals directly with the states and with the union territory. For example, in our Constitution of India, there is Part 8. Part 8 deals with the union territories. Article 239 to 241. According to these articles, provisions, no doubt we are having High Court, judiciary we are having. We may have legislature also, but still after having your legislature, a small group of council of ministers, if government of India provides, recommends, the power structure is not the same like that of the state. After having council of ministers, after having your high court and all that, you are still slashed by the central government. You will remain under the control of central government. You have to dance to the tune of central government. But this is not so far as the state is concerned. There is part 6. Part 8 deals with union territories. Then there is part 6 from article 152 to 247. It deals with the states. The provisions for the states are dealt with by these articles. Then The most important that how the power structure is defined in the constitution, how the executive power of the state as well as the Union of India is defined under the constitution. There are three lists provided in the schedule attached to the Constitution of India. These three lists are called: number one is the Union list, number two is the state list, number three is the concurrent list. These three lists defines the powers of the states as well as the Union of India. The state will legislate on those subjects which are enumerated in the state list, and the union will exercise jurisdiction over these subjects which are enumerated in the union list. Then there is one common list, concurrent list, which is different to these two. Whatever is not contained in the two list is contained in the third list. And while legislating, concurrence is required. Suppose if something is the subject in which the state is also interested, the state stake is involved. Before legislating on that subject, the, the union has to seek concurrence of the state government. So this is the power structure is beautifully defined, laid down under the constitutional provisions. Then there is Article 73, which speaks about the extent of executive power and how it will be exercised by the President of India. 74 lays the provisions regarding the Council of Ministers, who will advise the President, who will aid and advise the President. So we all know that according to the constitutional position, the President is a titular head of the state. The power is exercised by the Council of Ministers. And the President of India, according to Article 74, can't refuse to the Council of Ministers. So, Council of Ministers is the powerful body in the Union of India, in the Union, who runs the government, who legislate, who passes the legislations while sitting in the parliament. And if the government, the party who enjoys the majority in the parliament, and and they have the government, so one can imagine the power of that political party or the government. So, this is the power structure as laid down in the Constitution of India. My basic fundamental point on which my discussion was on the underlying difference of the state vis-a-vis the union territory. Now, and by referring to the example of Jammu and Kashmir, one will not find any difficulty to understand the difference between the state and a union territory. So, as a constitutional concept, the state is a very powerful unit which is independent, which is autonomous, because it has its own legislature. They have the people elect their representatives to the bicam to the state assembly. The government can, the state assembly can legislate. They have their own council of ministers. The grievances of the people are well and properly settled when you are a state, because you have your own elected representatives who are representing your interests in the assembly, in the law-making body. They can persuade the government to further your interests. This one basic difference you will not find in union territory. There is nobody for you. Nobody is representing you. You cannot access to anybody to further your interests. You are directly in deal with the bureaucratic setup, and you know that our bureaucratic setup is aristocratic. They won't like to hear you. This is aristocratic setup. IAS, IPS, and others, they hardly hear you. So, one basic difference between the union territory and the state is in, in union territory, you have no say at all, because bureaucrat will not listen to you, and when he does not listen to you, you have no gateway, you have no redressal, because the element of representation of the people's interest is missing here. So understand this fundamental difference. You enjoy more rights When you are a state, you enjoy little rights when you are a union territory. You have no representation in the union territory. You have representation in the state when you are a state. Ministers comes to you, they listens to you, they take part in your day-to-day life. They further your interests on the highest level, on the government level, which you cannot when you are a union territory. Because union territory is directly controlled by the union government. It is the president who elects administrator, and it is the administrator who further elects its own advisors and all that from the bureaucracy, mostly from the bureaucracy. So question of representation of people's interest does not arise here. So if you are aggrieved, where will you go? Though courts are there, the system of judiciary is there, no doubt. But always you don't have to go to knock the doors of the judiciary. There are many things which are resolved by your representatives, which you miss when you are a union territory. So this is the basic underlying difference between the state and the union territory. Now, I will directly take you to the articles which deals with the state and the union territory. Let's examine the first article, Article 239. Bear with me for a while. I will share with you the concerned article. So now you can see the basic article 239, Administration of Union Territories. I will read it out for your benefit. Save as otherwise provided by Parliament by law, every union territory shall be administered by the President acting to such extent as he thinks fit, though an administrator to be appointed by him with such designation as he may specify. Notwithstanding anything contained in Part 6, the President may appoint the Governor of a state as the administrator of an adjoining union territory, and where a governor is so appointed, he shall exercise his functions as such administrator independently of his council of ministers. Now, this article is very clear. It talks about administration of union territories, which I have explained well earlier for your information, that it is a union UT's administrative unit which is directly governed by the union government. Right? LGs, the governor may be appointed, and see the structure here according to this article. Governor is when governor is appointed, he independently exercise his functions of the council of ministers. Say, for example, if council of ministers are appointed, it seems, according to the mandate of the governor, the Article 239, that governor remains powerful because he is independent. He is independently exercising his functions, which means he can block the council of ministers, as it happens, for example, in New Delhi. If Mr. Kejriwal, the chief minister, who wish to do something, and it goes to the governor, LG there, he always seems to block his choice. So this difference is there. Even if council of ministers are there, they will not enjoy the same content, the same quality, the same jurisdiction, the same powers as the council of ministers enjoy when they are a state. By merely reading this article, barely reading this article, you can find out the difference, the basic difference between the union territory and the state. On its contrary, when you go to study Article 152 to 247 along with three lists, then you will see the wide range of powers of the Council of Ministers. And governor in a state is a titular head, like the President of India for the Union of India. Governor can't block anything when it is a state. And you know the repercussions, and you know the repercussions when a chief minister of the state in the union territory wishes to do something and he is blocked by the governor, the LG. It affects the capability of the chief minister who wants to do something for the people, for the public, but he is blocked to do that by the independent governor or the LG. It hinders, it impedes your progress. It will not expedite the progress because though the chief minister is elected by the people in the union territory, but he does not enjoy the same powers as he enjoys in the state, full-fledged state. So the subjects in his hands are very limited. For example, in Delhi, the police is directly under the control of the home ministry, union home ministry. The chief minister can do nothing. Police will turn down his every request because police know we are not under his control. So when it happens, if chief minister can't do anything with the police, it will definitely affects your law and order position, the situation there. Chief minister will not be in a position to control the law and order situation there. The instructions has to be sought from the home ministry. So autonomy of the chief minister is slashed. So he can't do anything. Had he been the full-fledged state, the chief minister in a state, he has never to face such issues of jurisdiction, because so far as the state is concerned, its mandate is very, very clear. There is no ambiguity. 152 to 247 articles are very clear. Three lists are very clear. But the same chief minister under UT becomes a puppet, becomes a powerless, because he has no autonomy. The important subjects are not within his domain, where he could lay his hand to do some better for the public. Subjects are limited. So you understand the politics also behind this. Say, for example, in New Delhi, Delhi government, it is a government by the AAP party, and the central government is by the BJP. Obviously, conflict of interests is there, and politics behind it can play some game. So these are all important factors which our masses has to consider, has to take into consideration. while understanding the concept of state and the union territory. Hopefully, what I have tried to explain in a very simple manner about the underlying difference between the state and the union territory will be well understood by you, and you will see the repercussions when a full-fledged state is converted into a union territory and vice versa, and union UT into a state. The difference will be visible to you very clearly. With this, I will end my this editorial, and we will come with some other editorial of public importance, perceptive. Till then, I will say goodbye. Thank you. Have a good day.